In the United States, a nation of over 330 million people with diverse demographic compositions, the role of minority groups in shaping major institutions raises intriguing and uncomfortable questions about power distribution, group cohesion, and the passive consent of the majority. Jewish Americans, comprising approximately 2.4% of the population, around 7.5 million individuals as of 2025, have exerted significant and arguably disproportionate influence on civil rights law, media, finance, and politics through dedicated organizational networks formed in the early 20th century. This phenomenon, while statistically improbable given the group's small size, is not merely a benign outcome of merit or pluralism. It reflects a highly effective strategy of focused mobilization that has allowed a tiny minority to imprint its priorities on laws and norms binding the overwhelming majority. Critics argue this raises legitimate concerns about democratic equity, representation, and whether such concentrated influence distorts national interests in favor of particularistic agendas, even as defenders frame it as exemplary minority achievement in an open society. The statistical improbability borders on the extraordinary. In a country where non-Jewish whites historically constituted nearly 90% of the population during the mid-20th century, a 2% minority playing a pivotal role in drafting foundational laws like the Civil Rights Act of 1964 and Voting Rights Act of 1965 defies simple explanations of random merit. Through organizations such as the American Jewish Committee, 1906, Anti-Defamation League, 1913, American Jewish Congress, 1918, and decisive involvement in the NAACP, 1909, and ACLU, 1920, Jewish advocates not only co-authored these statutes but expanded protections in ways that extended far beyond original intents, introducing concepts like disparate impact liability and hostile environment standards that shifted burdens onto majorities. This was facilitated by stark overrepresentation in the legal profession, estimated 10 to 15% of lawyers, vastly exceeding population share, and judiciary, historically up to 19% of federal appellate judges, providing outsized leverage to set precedents on hate crime enhancements, speech restrictions, and protected characteristics. In finance and media, similar patterns of concentration, often attributed to cultural emphasis on education and networking, have enabled agenda-setting influence on economic policies and narrative framing, prompting critics to question whether this constitutes organic success or a form of entrenched elite capture that disadvantages less cohesive groups. Public cognition of this influence remains disturbingly low, contributing to a sense of disconnection and occasional resentment among the broader population. Many Americans are unaware of the extent to which groups like the ADL have trained hundreds of thousands of law enforcement officers on bias detection or how SPLC designations shape corporate deplatforming decisions, effectively granting private entities quasi-judicial power over speech and association. This opacity is not accidental. The technical, behind-the-scenes nature of legal advocacy, amicus briefs, model statutes, regulatory trainings, allows profound changes to occur without broad debate or consent. Psychological and social factors exacerbate this. Historical guilt over past discrimination discourages scrutiny, while laws framed as universal protections obscure their origins in specific minority interests. In a pluralistic democracy, majorities often defer to perceived experts, but this deference can mask imbalances where a small group's priorities, such as expansive definitions of anti-Semitism via IHRA adoptions, become national policy, potentially at the expense of free expression or competing viewpoints. The plausibility of a 1 to 2% minority achieving such sway lies in exceptional cohesion and long-term strategy, qualities that diffuse majorities rarely match. Unlike fragmented larger groups, Jewish communities benefited from historical structures like B'nai B'rith, 1843, synagogues, and intergenerational networks that enabled unified funding, planning, and mobilization, from challenging 1920s immigration quotas to driving 1960s civil rights expansions and contemporary hate speech frameworks. In politics, with Jewish representation reaching 9 to 10% of senators in recent Congresses despite tiny population share, this translates to amplified voice on issues like foreign aid or anti-Semitism legislation. Critics point out that this cohesion, while admirable in resilience, can appear insular, prioritizing group interests in ways that strain broader social trust, especially when influence extends to media ownership or financial sectors, where overrepresentation fuels perceptions of gatekeeping. If questioning these patterns invites accusations of bias, it may reflect protective societal norms, but it also stifles legitimate debate about power imbalances in a supposed equality-based system. Ultimately, this dynamic is not entirely unique. Parallels exist with other high-achieving minorities in tech or business, but its scale in law and policy invites sharper scrutiny. The control narrative, while often exaggerated into conspiracy, stems from real disparities that oversimplification ignores at society's peril. In a democracy, concentrated influence by any group risks alienating the majority and undermining legitimacy, particularly when changes like expansive bias laws impose costs on free speech or traditional norms without explicit consent. Raising awareness through transparent education and open discourse is essential to ensure such leverage serves collective good rather than fostering division or backlash. Without critical examination, the improbable becomes the unchallengeable, challenging the very foundations of equitable pluralism. The unsettling implications of concentrated minority power. The examination of Jewish advocacy networks in American legal and institutional evolution exposes a deeply troubling dynamic. A demographic minority of just 2.4% has, through exceptional cohesion, strategic foresight, and overrepresentation in key professions, secured influence far beyond what raw numbers would suggest, imprinting its priorities on civil rights laws, hate crime frameworks, and norms governing speech and discrimination that bind a nation of 330 million. Organizations like the AJC, ADL, AJ Congress, and their pivotal roles in the NAACP and ACLU did not merely contribute. They often led the drafting and interpretive expansion of statutes from the 1964 Civil Rights Act to modern IHRA adoptions, leveraging legal expertise, 10 to 15% of lawyers, and judicial positions to embed doctrines like disparate impact and hostile environment that shifted societal burdens in lasting ways. This improbable manipulation, achieved amid a historically overwhelming non-Jewish majority, highlights the vulnerabilities of democratic pluralism. Diffuse groups struggle to mobilize with comparable unity, allowing focused minorities to set agendas with minimal resistance. Public ignorance of these mechanisms, whether ADL trainings for law enforcement or SPLC designations driving deplatforming, perpetuates a system where influence operates opaquely, framed as universal progress while advancing particular interests. Historical guilt, social taboos against scrutiny, and deference to experts further entrench this imbalance, stifling debate and fostering underground resentment that can morph into outright hostility. Critically, while merit and resilience explain much, the scale invites legitimate concern. When a tiny group's networks yield near veto power over national policy, evident in political overrepresentation, around 10% of senators, and cultural gatekeeping, the result risks alienating the majority and undermining democratic legitimacy. Parallels with other high-achieving minorities notwithstanding, this case stands out for its depth in law and policy, where outcomes impose costs on free expression and traditional norms without explicit majority consent. True pluralism demands transparency and balanced discourse. Without it, the improbable becomes the unaccountable, threatening social cohesion in a nation built on equitable representation. Acknowledging these patterns openly, free from exaggeration or suppression, is essential to preserving trust and ensuring influence serves the whole rather than a part.